Hello there, please subscribe so you can receive my new videos. Thanks. A federal judge in San Francisco has shut down Donald Trump's campaign against Twitter, ruling Friday that the twice-impeached former president's claims the social media massive violated his First Amendment rights were essentially BS. In a 17-page order passed down Friday, U.S. District Judge James Donato upheld the company's choice in January 2021 to kick the former president off its service to stop him from similarly inciting his supporters to violently oppose the results of the 2020 election. Twitter consequently has no duty to let Trump again on the platform. Last year, Trump sued Twitter after he was suspended completely from tweeting for breaking the app's guidelines against glorification of violence, with tweets extensively viewed as fanning the flames simply after the lethal January 6 Capitol riot. After starting his personal Twitter clone, the floundering Truth Social, Trump stated in an interview that he wouldn't return to Twitter even if the ban was lifted by incoming proprietor Elon Musk. "I was dissatisfied by the way I was dealt with by Twitter," Trump informed CNBC. "I won't be going again on Twitter." In tossing out Trump's suit, which was filed alongside with the American Conservative Union and 5 individual customers, together with anti-vaxxer conspiracy theorists Naomi Wolf and Wayne Allen Root, Donato demolished each of the ex-commander-in-chief's arguments one by one. Plaintiff's essential claim is that defendants have censored plaintiff's Twitter accounts in violation of their right to free speech underneath the First Amendment to the United States Constitution, Donato wrote in the order. Plaintiffs are not beginning from a position of strength. Put simply, the First Amendment applies solely to governmental abridgments of speech and not to alleged abridgments by non-public companies, the order explains, noting that Twitter is a non-public company. An amended grievance filed by Trump merely provides a grab bag of allegations to the impact that some Democratic individuals of Congress desired Mr. Trump and the views he espoused to be banned from Twitter. The order continues, because such content and views were contrary to those legislators' preferred points of view. But even if some legislators, such as Senator Mark Warner, DVI, spoke out against Trump's crude and probably risky online behavior, and then Senator Kamala Harris called for Twitter to suspend Trump's account, Donato pointed out that public officers are perfectly free to categorical opinions except being deemed the respectable voice of the state. Government in our republic of elected representatives would be impossible otherwise. Donato ruled that Trump's position fell short of the mark, even giving him every gain of the doubt. Further, Donato wrote, the case citations cited by Trump's legal professionals managed to undercut their very own arguments. In his preliminary complaint, Trump additionally claimed that Section 230, a regulation that protects online systems such as Twitter from being sued over content posted by users, is unconstitutional. As president, Trump launched an all-out assault on Section 230 in an strive to force Twitter to reinstate his account, which had almost 90 million followers prior to the ban. Trump's assaults on Section 230 comply with a familiar pattern. They usually appear to follow a perceived moderate by social media companies, the nonprofit Electronic Frontier Foundation stated in December 2020. Thanks for watching. Please don't forget to subscribe.